Hello everybody, it's your immigration attorney Ruiz, and I'm here with you today because I want to talk to you about one of the most common issues that we face in immigration, and that is the 3-year bar, the 10-year bar, and the permanent bar. Now, I want you to be informed about what these bars are, what they mean, what they could disqualify you from. I want you to be able to understand what's going on with your case. So I'm going to talk to you about them. The 3, the 10, and the permanent bar. The 3-year, 10-year, and permanent bar. The law changed on April 1st, 1997. That's when Congress passed a new law that created unlawful presence and the bars. The 3-year, 10-year, and the permanent bar. So since April 1st, 1997, since that date on, if you have been unlawfully present in the United States for more than 180 days, then you will have a 3-year bar if you leave the United States. So let's say, doing simple math, April 1st, 1997, so 180 days is 6 months. So if you were here from April 1st to October 1st, that's 180 days. That means that if you leave after October 1st of 1997, let me rephrase, if you left after April 1st, 1997, you would have a 3-year bar because from April 1st to October 1st is 180 days, and therefore your departure after 180 days of unlawful presence will trigger a 3-year bar. If you have been unlawfully present for more than a year, then your departure will trigger a 10-year bar. So April 1st, 97 to April 8th, 1998. That's about a year. So your departure after a year of unlawful presence is going to trigger a 10-year bar. Now, a lot of people say, well, nobody told me. I didn't get a letter. Immigration doesn't know. So what do you mean I have a bar? Well, the bar is an automatic bar, right? Nobody knows when you left the United States, really. So if you left on October 15th, 1997, and nobody found out, well, you still left. You and I know you left, so we know that you have a bar. So when you come to our office and you consult with an attorney here at our office, we're going to ask you questions to determine your eligibility. We're going to say, how many times have you entered? How many times have you left? So, and that's what immigration does as well. They ask you about your entries and your departures. So when they see, and when we see that you entered more than one time and that you triggered the bar, we're going to let you know, hey, you don't qualify. And today specifically, I'm not going to talk about any waivers, really. I really want to talk about what triggers the bars and what's going to make you inadmissible because of these bars. But there are waivers in certain categories and with certain processes. So 180 days and more, but less than a year, 3-year bar. More than a year, a 10-year bar. So you left, triggered. The bar is triggered, okay? So when you apply for your benefits, and typically this happens when you're applying for a benefit at the consulate, you go to your interview, they're like, okay, well, you came in on this date, you triggered the bar because you left on this date, so you'll have to wait until, and they'll tell you, 10 years or 3 years, or if some of that time has already passed by, they'll tell you how long you have to wait or when your bar has been fulfilled. When can you apply to enter the United States again without a waiver? So as long as you fulfill your 3-year bar or your 10-year bar, you don't need a waiver, but you do need to be able to prove that those 3 years or 10 years were spent outside of the United States. Bank statements, school records, work records, lease agreements, all of that can be used to prove that, hey, I've been outside 3 years, I'm good, let me back in, please. Now the permanent bar, that's the tricky one. That's very difficult. So the permanent bar says that if you've been unlawfully present in the United States for more than a year, departed, and then attempted to re-enter illegally or re-entered illegally, then you will have the permanent bar, which is also a 10-year bar, but we do call it call it something else just to differentiate, and because the permanent bar is much more serious and definitely requires a waiver to re-enter even after the 10 years have been met. So a person who, let's say, came in, who was here April 1st, 1997, they departed the United States on January 15th, 2000. You have more than 1 year of unlawful presence. You left the United States, and then they attempted to re-enter, or they actually re-entered the United States. When you come to our office and we do our consultation, we're doing an assessment to determine whether you're barred or whether you qualify for the benefit you're seeking. And that's when we'll tell you, hey, you don't qualify because of this reason. And when you apply for the benefit, if we didn't catch it, or if your attorney didn't catch it, when you apply for the immigration benefit, immigration's going to catch it, right? And the problem with, getting good help is that you need to be able to find these mistakes, these issues, so that you don't apply for the benefit if you don't qualify, because otherwise you're going to end up in removal proceedings. Now, as you know, because you watched my VAWA series, VAWA is a program for people who have been victims of domestic violence at the hands of their U.S. citizen parents, permanent resident parent, U.S. citizen or permanent resident spouse, or U.S. citizen children. If we can tie your entries and departures to the abuse that you were suffering, then that can be waived. For the U visa, which is for people who are victims of serious crime, that has the strongest waiver in immigration. So if you are a victim of domestic violence or a victim of serious crime, you can apply, even if you have a permanent bar or a 3 or 10 year bar, for VAWA, if you can tie it to the abuse, or for the U visa, they will waive that for you as long as you can show that you deserve for it to be waived. So there are ways to get past this, but typically there's no waiver for the permanent bar, and the 3 and 10 year bar do have a waiver, but they do require qualifying relatives. It's important that you find good help, that you find an attorney who understands the 3 and 10 year bar and the permanent bar, so that we can properly help you navigate your case, and to, unfortunately, when it applies, to help you not apply for the benefit, because then you will end up in removal proceedings. As you know, I'm your immigration attorney, Ruiz, and I'm here to keep you updated. I want you to know what's going on with your case. I want you to know if you qualify for the benefits that you're wanting to apply for. If you need any help, give us a call. That's what we're here for. I'm your immigration attorney, Ruiz.